So what are ex parte applications? First of all, let's begin by looking at the ex parte applications. Our legal system in Zambia, in Canada, as well as in England, they have developed from what is known as the common law. So Zambia, Australia, Canada, England, all these countries are known as common law countries. So common law countries have similar judicial traditions, okay? Very similar traditions. In fact, they are the same. Even terms, okay? Like the term ex parte. So it's Latin, it's corrupted Latin, ex parte, corrupted Latin, but it's English. It's from the English legal systems, okay? So the systems are pretty similar. The rules are very similar, if not the same. And the law that governs ex parte applications, inter parte hearings, and everything, they are basically the same. You might benefit from knowing that in addition to the High Court rules in Zambia, there is another book known as the White Book, which is used in Zambian practice, okay? It is an English book. It's an English, it's an English book of rules of civil procedure. It's known as the White Book, okay? Supreme Court Rules 1998, I believe. So what is current law in Zambia right now is what the English legal system was doing in 1998. So there's been a lot of changes from 1998 Kubasungu, but there's not been those changes in Zambia, okay? So I just want to create this background so that nganalanda mumfwe umondelo share. Okay? Now, the standard for any hearing in the common law world is that a judge hears from two sides, okay? Before they render a decision, they hear from two sides. So let's assume that I'm Judge Munsha, okay? And then there is person Nina Ntwalaita, Martin, and then there is Peter, all right? Peter and so Martin and Peter, Martin Kaumba Musole and Peter Chilufia. So ex parte orders. So let's assume there is Peter and Martin. The rule is before a judge hears kumfwa kumbarishonse. So Peter and Martin, they come before judge, okay, before Judge Munsha. I hear from Peter, I hear from Martin, and then I make a decision. The biggest quality that judges must have is the ability to listen to both sides. When two parties are appearing before you as a judge, it's known as an inter-party hearing. Inter-party. Inter-party means part A, part B. All right? It could be many other parties, but let's simplify it. Two parties, Peter and Martin, they've appeared before a judge. Okay? And then Peter explains, oh, judge, this is the problem I have with Martin. And then Naena Martin alondorola. Peter alandevere na mwishiba Martin nadimushtisha Benz at 20,000 and Pirafie 18,000. Na shalana 2,000. So imoba judge. Na mipela evidence through affidavits. Na lemba affidavit okobati ine nadimushtisha Benz at 20,000 elo nomba sa chahan. Asa ndipira kwa 18,000. Alexa, oh, 2,000. So imweba judge, mwebeni andipire 2,000. Na mpokeni 2,000. Janden 2,000. Epitoy. Elo Martin, aye judge vere, oyu Peter rebe po ufipantu. 2,000 alera ndapokale na mulipira. Na mulipire shan. Na mulipire on such and such a day. Elo nomba judge, after aumfwa from the two sides. Contract epo idi, uyaranda ati 18,000, uyaranda 2,000. Ero asasa la judge vere. Between the two, kweno na chiteke roko watalande chinka ni nani ni Peter or ni Martin. Ero apanga decision, and that decision becomes binding. Inter-party. That is what it means. Okay. Inter-party, two parties. Now, there are circumstances in which a person can appear before a judge alone, weka, In other words, wayaweka. So you have issues with, it's Peter and Martin. You have issues with Martin. Now, before tamulaya kuli judge, at the same time, ukuya mukulubulula, Peter aya kuli judge eka. Elo aya lomba what is known as an ex-parte order. Alieka. That's what it means when they say ex-parte. Ex-parte means udiweka or ayaweka. You go alone to talk to a judge, and what you are looking for from a judge varies. Okay. In some cases, you can say, before Martin comes to respond to the lawsuit, I want you as a judge, mumpeleko, a temporary order, nsunge whatever money I have, something like that, okay? Now, mumpeleko a temporary order, uyu Martin, adindipirako kale 18,000. No, mandevo mumpeleko a temporary order, if there is a kind of a relationship, for example, kumukanyo Martin, Elisa mukumpange chongo ko office, something like that. Okay? It's true, I am seeking 2,000 kwacha that he is owing me. But in the meantime, ale mpanga sane chongo, Elisa mukumpangire chongo ko office. So therefore mumpeleko a temporary order, so that when the matter is heard finally, mukachita decide. But in the meantime, peleniko a temporary order, mpokololeniko nchiteniko cover panono during this time. So for that application, you go alone as Peter. So why could he judge? Judge averenga affidavit yobe elwa kupela what is known as an ex-parte temporary order. Ex-parte simply means one party. All right? And you get that order, and it's an order of court. Na judge nasa inapo. It's an order. It's ex-parte in the sense that waideweka. One. Secondly, it's ex-parte in the sense that it's sometimes temporary. All right? Until Martin and Peter come before you as a judge to hear from you. When a judge is granting what is known as an ex-parte order, much of it is what is known as discretionary. So by discretionary, what we mean is, judges a lot of wide discretion. Discretion this is what I believe. So it's discretion. And so that is what it is. So a judge has wide discretion. Modern standard, of course, is that you need to hear from two parties. The issue I have as an outsider to the Zambian jurisdiction, as an outsider looking in, is that even when I'm talking to my friends, okay, of the Zambian bar, they've always taken it for granted. The few people that have discussed these issues with, they've always taken it for granted, as long as somebody applies for an ex-parte order and an inter-parte hearing is set, it is okay to obtain that order. Right? But the problem is some of these ex-parte orders do not just end at trying to work on the temporary issue. Some of them are quite deep. Some of them go as far as giving permanent rights. For example, what happened in the KCM matter, right? In the KCM matter, it was an ex-parte order to appoint a liquidator. Now, the reason we objected to that was that the ex-parte order was too powerful, extremely powerful. Even if you called it a temporary order, it gave one party a lot more power. Now, of course, that is done under the Companies Act, right? Under the Companies Act, under the liquidation or whatever, receivership acts and everything like that. But still more, it is too permanent to grant on the basis of one party making the application. That is the major concern that we had. Most of the jurisdictions here and in England, they have moved from granting interim injunctions as a matter of course. All right? They've moved on from that. The reason why they've moved on from that, granting interim injunctions on ex parte basis, is because they want to hear from both parties, from both parts. At least, even before they grant an interim injunction. In other words, the Zambian jurisdiction, honestly, it needs to interrogate itself as to why interim ex parte injunctions are granted so as readily as they are currently granted. I'm not saying that it is illegal. It is still legal. The question is, it betrays efficient administration of justice.